Welcome to another video from the Loud Little Ducky. We are going to be talking about Aaron Spencer's charges. We're going to basically going through the docket and looking at the documents from the gag order that the state filed as well as the court's order. In a previous video on this case, we talked about and went over the Arkansas Supreme Court's ruling to vacate the gag order. But we're going to look at what started all of that to even get to the Arkansas Supreme Court vacating this gag order. So let's jump into it. So here is what the docket looks like. I will link the docket in the description of this video. State of Arkansas versus Aaron Spencer. The filing date was November 27, 2024 in Lonoke Circuit Court. The case type is a felony and the status is the case is open. Case participants, it shows that the judge is Barbara Elmore. State of Arkansas plaintiff John Huggins is prosecuting attorney. Aaron Spencer is the defendant. And then lawyers for the defendant/respondent are Aaron Casanelli, Michael Kaiser, and Marianne Bird. The offenses are murder in the second degree on October 18th, 2024. It says Aaron Spencer was 36 at the time of this offense. They're charging him with second degree murder. Statute 510-103. No plea deal. It's a Class A felony, and it says the offense was, of course, committed on October 18, 2024 as well. So close to 1 year dealing with this, but just recently out to where the public and the world can know about what is happening in Lonoke County. So here we have this filed on November 27, 2024 in the Circuit Court of Lonoke County, Arkansas, 23rd Judicial District, 1st Division. Murder 2, Class A felony. Felony with a firearm. State of Arkansas versus Aaron Spencer. Information. I, Chuck Graham, prosecuting attorney within and for the 23rd Judicial Court of the State of Arkansas, which consists of Lonoke County, in the name of and by authority of the State of Arkansas, on information, accuse the defendant of the crimes of murder 2, Class A felony in violation of ACA 510-103, and felony with a firearm in violation of ACA 1690-120, committed as follows. The State of Arkansas alleges that on or about October 8, 2024, in Lonoke County, Arkansas, the defendant, count 1, did knowingly cause the death of another person under circumstances manifesting extreme indifference to the value of human life, a Class A felony in violation of ACA 510-103, to wit, Michael Fossler, against the peace and dignity of the State of Arkansas. So here they say that Aaron Spencer manifested extreme indifference to the value of human life. Well, in his world, it was value a predator's life or value his daughter's life. And he chose that his daughter's life was more valuable than the predator, while the predator was kidnapping his daughter and running and starting crap out on bail. Enhancement. Any person convicted of any offense that is classified by the laws of this state as a felony who employed any firearm or any character as a means of committing or escaping from the felony, in the discretion of the sentencing court, may be subject to an additional period of confinement in the state penitentiary for a period not to exceed 15 years in violation of ACA 1690-120. So that is the charging document. Now, Aaron Spencer is giving notice of intent to raise justification as a defense. So they are letting the prosecutors know we are going to make this a self-defense case, basically. That is our defense. And this was filed December 3rd, 2024. Comes now the defendant, Aaron Spencer, by and through his attorneys, Aaron Casanelli and Michael Kaiser of Lassiter and Casanelli, and for his notice of intent to raise justification as a defense states and alleges as follows. Number 1, the defendant is charged with a felony offense. 2, the defendant does not or does indeed intend to raise justification as a defense under Arkansas Code 52604, 606, and 607 in the above referenced case. Wherefore, the defendant is hereby giving notice to the state and to the court of his intent to raise justification as a defense in this matter. And they signed it and signed a certificate of service. I hereby certify the true and accurate copy of the foregoing document was delivered on December 3rd, 2024 to Chief DPA John Huggins via e-filing and by email. And this is signed by Michael Kaiser. So this is just a copy from December 4th, 2024, Judge Elmore. And they were doing a pretrial conference on March 17th, 2025, and they were going to do a jury trial conference, maybe, surely not just a jury trial, on March 19th through the 21st of March of 2025. That obviously did not happen. So we will find out as we continue to go through the docket. So now we get to where the state has motioned for a gag order with the court. So this is what started everything trying to silence Aaron Spencer and his family and anybody else who dares talk about this case. They wanted to silence this and do this in darkness, no transparency. Don't let anybody know what we're doing here. And this gag order was filed on December 4th, 2024. Comes now the State of Arkansas by John Huggins, Chief Deputy Prosecuting Attorney, and for its motion for gag order doth state. Okay, another Shakespearean we got here. That Aaron Spencer is charged with murder in the second degree, a Class A felony in violation of ACA 510-103, and felony with a firearm in violation of ACA 1690-120. 2, that these charges stem from his arrest on October 8th, 2024. 3, the defendant Spencer's arrest has garnered media attention and coverage throughout Arkansas and the nation. Gee, I wonder why. 4, additionally, details of his arrest have spread via social media. Yeah, y'all are embarrassed. Y'all let a predator out. He reoffended. And he got killed for doing it. And the girl, Aaron Spencer's daughter, was re-victimized because of y'all setting a low bond and letting this guy out. So some of the blood of all this and some of the re-victimization and trauma that this Aaron Spencer's daughter faced is on your hands, court. Sorry, but that's the way I feel. The defense counsel has issued a press release, see attachment A. Oh no. The defense counsel has also given television interviews. In one interview, counsel states, "We feel very confident that this community is going to come to Aaron's side because every one of them would have done the same thing for their child or their neighbor's child or a member of their family." Attorney Castanelli went on to say, "We look forward to the public being more involved in this process, certainly more than they are today." Well, they got their wish, and thus far, it seems like the defense counsel is right. They're going to Aaron's side and asking the state, "What the hell are you doing charging this man?" Is it a sad circumstance? Yeah, but it's an incident that should have never happened. Aaron Spencer should have never even had to go defend his daughter. And he wouldn't have had to had you kept him in jail. That the state argues that the dissemination by any means of public communication uh, of any out of court statements relating to this case may interfere with the rights of the defendant and the state of Arizona to receive a fair trial and impartial trial. Nobody's worried about the state of Arizona's right to a fair trial. Or Arkansas. I'm sorry. I am covering a case in Arizona as well as Arkansas. And so I apologize if I get those states mixed up. But Aaron Spencer is out of Arkansas. 8, that the need to preserve the integrity of the jury pool is paramount importance to ensure the right of a fair trial to both the state and the defendant. 9, the state prays that the court order that no party to this action, nor any attorney nor agency connected with this case, directly or indirectly, nor any judicial employee or officer of this court, nor any public official now holding office, including but not limited to law enforcement officials, nor any agent, deputy, or employee of such persons, nor any person subpoenaed to testify at the trial of this case. And that right there, that is asking way too much. You're asking to silence everybody, and you cannot do that. You can silence some temporarily, but you cannot silence everybody. Shall release or authorize the release for public dissemination of any purported extrajudicial statements of the defendant relating to this cause, release or authorize the release of any documents, exhibits of any evidence, the admissibility of which may have to be determined by the court. 3, make any statements for public dissemination as to the existence or possible existence of any document, exhibit, or any other evidence. Express outside of the court an opinion or make any comment for public dissemination as to the weight, value, or effect of any evidence as tending to establish the guilt or innocence of the defendant. Make any statement outside of court for public dissemination to weigh, value, or affect any testimony that has been given. Yeah, don't be putting out there whether you think the defendant is innocent or guilty. They did not want people to be able to say anything about that because it wasn't in their favor. Now, if everybody was out there saying, "Oh, Aaron Spencer is guilty," the state would have loved that. The defense wouldn't have, and maybe they would have made a motion for a gag order. Probably not this bad. But the state doesn't like it, and nobody likes their case. And you know what? The state is supposed to be representing the people. These prosecutors work on behalf of the community and their state. Does this sound like they care about what their community or state people that they care what they think? No. Just like Massachusetts, they don't care. They're going to do this. Massachusetts at least will do it in front of your face. Arkansas is having to do it in front of your face now, but they were trying to do it in silence. Issue any statement for public dissemination as to the identity of any prospective witness or their probable testimony or the effect thereof. 7. Make any out-of-court statement for public dissemination as to the weight, value, source, or effect of purported evidence alleged to have been accumulated as a result of the investigation of this matter, as well as make any statement for public dissemination as to the context, nature, substance, or effect of any testimony which may be given at any proceeding related to this matter with an attorney of record or any agent thereof. Wherefore, the state prays that the motion for gag order be ordered. Respectfully submitted by John Huggins, certificate of service, and they filed it to the correct people. This is insane that you want this. And here's the press release that the prosecutors were complaining about, and they don't like it. They don't want people to be able to make statements. So, Casanelli and Kaiser, which are two of the attorneys for Aaron Spencer, stated or released the statement late Wednesday. Spencer's attorney, Aaron Casanelli, and Michael Kaiser released a statement that read, "We are not just disappointed, we are outraged by this decision. Aaron Spencer is a decorated war hero who protected his country and a loving father whose heroic actions protected his family. He is certainly not a criminal. He did what any father would do, and any trained combat veteran would do to protect his children from a predator. This predator repeatedly violated his child, and undeterred by criminal charges and release on a low bond that pales in comparison to what was required of Aaron, kidnapping her in the dark of the night to continue his assaults on her." And these are sexual in nature. Essay. "The systemic failures for decades that permitted this man to continue his abuse of women and children for years, culminating in the face of a father who finally stopped him. No matter what the prosecuting attorney may do to Aaron, he was able to save his child and prevent this man's continued acts of sexual violence against the most vulnerable among us, a child base. Nothing could be more important than that. While the prosecutor has made clear his intent to send Aaron to prison, even targeting his use of legally owned firearms, and in spite of his past experiences in combat in this country, it is not the prosecutor who will ultimately decide justice. It is the citizens. We believe the citizens of our country and of this state will not allow this injustice, that this community will not allow a father protecting his child from a serial predator to be treated as a criminal. The repeated traumas Aaron's family has endured over the last 6 months are unimaginable. Sadly, the prosecutor's decision perpetuates these horrors instead of protecting legitimate victims and punishing true criminal offenders. Instead of targeting this heroic father, the prosecutor should be working to figure out how the system failed to protect this innocent victim, this innocent child, and instead resulted in her father having to do so. We appreciate the support of so many who have voiced their outrage over the treatment of Aaron. His child and the rest of his family have suffered. We will stand up and fight for our right to protect ourselves and our children and will not be deterred by this unjust decision. Please keep Aaron and his family in your prayers as they continue to heal from past events while now managing a criminal case. We look forward to Aaron's day in court and to the end of his family's nightmare. Did this hurt your fifis, prosecutors? That they're calling you out like this? You could do something about it, and it's not silencing them. Then there is an attorney, or there's an email that this is filed December 5th, 2024, where they talk about the court will allow 5 days. He says, is this 5 business days? I'm guessing this is to respond or something. And then, so originally he wanted 14 days to file a response before the court rules on the gag order motion. And he didn't get 14 days, he got 5 days for a response. Then there's an email that goes out on December 10th where they were sent the order by the judge. And so we went over the order because I believe it was attached in the Supreme Court thing, but we'll kind of go over it here as well. They essentially just adopted what the prosecution asked for and turned it into an order. So it says, in the view of the apparent public interest in this case and extensive news media coverage as a result of such interest, and because it appears to the court that the dissemination by any means of the public communication of any out-of-court statements relating to this case may interfere with the rights of the defendant and state of Arkansas to receive a fair trial and impartial trial, and further seek a fair balance between the constitutional guarantees for a free press, the following order is hereby entered. So it is ordered all those people that the prosecution wanted. Neither, and then she adds in more because the prosecution didn't add enough. Neither shall the defendant nor his family shall to any of the following. Do not release these things, don't release exhibits, don't release anything about this case, don't say anything about this case. If you are related to this case or related to somebody that is in this case, you cannot talk. If you're going to attend the trial to watch it, you're not allowed to talk. Does nobody say a single word. If this judge hears Aaron Spencer come out of anybody's mouth, she will hold you in contempt, probably. This is unconstitutional, which is why the Arkansas Supreme Court said, no, ma'am. No, prosecutors, you should have never asked for this. You knew that this was unconstitutional. And Judge, this is ridiculous. They wanted her off the case, but currently she's still on the case. As far as I know, it's the same judge. From what we just looked at, that's who's listed on it. And so, they go over there, then they go over this order does not include, factual statements of the defendant's name, age, residence, occupation, or family status. So you're allowed to say Spencer. You just can't say, you can say how old Spencer is, you can say where he lives, you can say what he does for a living, and you can say whether he is single, divorced, whatever, I guess. You can talk about the circumstances of the arrest, namely the time and place. So you can say On this day, Aaron Spencer was arrested. And the investigation took this long. Like it took about 10 days. Nature, substance, and text of the charges, including a brief description of the offenses charged. So you can put out all this information about Aaron Spencer, but we're protecting his right to a fair trial. You can send the charging document basically out. You can talk about that or his arrest record. You can send that out. Don't mention that the guy that we arrested is possibly innocent. Do not say that. Quotations from or any reference without comment sent to public records of the court in this case to other public records or communications herefore disseminated to the public. Scheduling and result of any stage of the judicial proceeding held in open court or in an open and public session, which she was not holding public sessions. She was not doing things in open court. She closed the court. She also adds in that it does not include all parties and the defendant is under a gag order. So everybody is under a gag order. She also writes in, the order will help ensure all parties get a fair trial. The entire case is now sealed. So she sealed everything. And Arkansas Supreme Court said, no, release it all. Release it all. The public is going to see this. And y'all blew this case up to receive more media attention than it probably ever would have got because of this shit you tried to pull. Because people are going to know, why are you trying to hide shit? So that is the gag order and the charging information. The fact that Aaron Spencer is going to be using self-defense as his justifiable defense in fighting this murder 2 charge with the firearm enhancement. And that is all. And we will be back very soon for another one. Bye.